Uh, so, as I mentioned, the contract in section 9.1 has quite a few set of contingencies, and the closing date is keyed off of the satisfaction or waiver or actual or deemed satisfaction or waiver of the buyer's contingencies. 9.1A is where the seller is required to provide the mandatory disclosure statement and a property information sheet. The buyer has an physical inspection under subparagraph B. The buyer has a right to do a hazardous substance condition report or a phase 1 or phase 2 report. The buyer can do a soil inspection, seek government approvals, review and approve of title, which includes the underlying documents and a scaled and dimensioned plot plan of the easements, and conduct an ALTA survey, and do review the leases and estoppel certificates. The owners association, if this is part of a condominium, is also another contingency where the seller is supposed to provide some of the documents related to the property owners association. Other agreements such as management agreement, parking service agreement, etc. And then finally, contingency for new loan financing is part of the overall contingencies for the buyer. The buyer taking over existing notes, either assuming them or taking it subject to, is 9.1L. And finally, it's buyer to review and approve of the personal property that's included as part of the sale. Most of these have a start date, which is from the date of agreement or from the seller's delivery of the applicable due diligence document. From the buyer's perspective, it's let's talk about how would a buyer expand, and obviously a seller is going to try to tighten these contingencies. What our contract does not call for is a rent roll. So a buyer can add for a rent roll certified by the seller. This is really more appropriate for, let's say, an apartment building in a multifamily where there's a lot of units, and the buyer wants the seller to provide a rent roll that says how much is the monthly rent, how much is the security deposit, who's current on paying the rent, et cetera, et cetera. So this is a perfectly good addition by a buyer. Whether the seller is willing to do it or not really depends on, a lot of these depend on who's got the leverage and matter of negotiation between the parties. One other item for a buyer to add to expand the scope of buyer's contingencies is to add a requirement for the seller to provide a schedule of the leasing commissions and a copy of the agreements that the seller has with the current brokers. So the leasing commissions could come into play, for example, for existing leases that have been signed, and there may be commissions due to brokers still under those existing leases, or if a tenant exercises an option, there may be a broker who may be entitled to a commission. For example, if a tenant exercises an option to extend the term of a lease, then the broker may be entitled to a commission, additional commission. So from the buyer's perspective, it's a perfectly good due diligence item to determine what are the potential commissions that may be payable by the buyer as the then owner of the property if a tenant exercises an option to extend, purchase a right of first refusal, right of first offer, purchase option. That's a good add by buyer. We see in a lot of attorney-prepared contracts that the seller is required to provide the property taxes. It's not in part of the AIR contract, but it's a good add to get the property tax bills for the past 2-3 years. It's helpful to a buyer to see what those current taxes are and how much is the likely increase in the assessed value of the property after the sale is closed. Next is the financial information, such as the operating statements that the seller has for the past 3 years owning and operating the property. This is very valuable information to a buyer who can determine what's the typical cost to maintain and repair the property. What is the typical utility expenses that run? And this is very helpful for projecting the income in the future during the buyer's ownership of the property. Next is the seller's liability, fire and casualty insurance. Today, with the insurance business being so different and so some properties being so difficult to insure, it's very helpful for a buyer to get the seller's liability, fire, and casualty insurance policies and determine whether they can actually, whether the buyer can take over those policies, or this is going to be cost effective. Can the buyer actually get insurance? This has become a real issue, and whether I see some buyers adding as a contingency the ability to get insurance at reasonable premiums as a contingency to the deal. Continue with the list of the buyer's contingencies, getting copies of the certificates of the tenant's insurance policy. So if you want to find out how much insurance does the tenant carry, and that's going to be very helpful for the buyer to determine what kind of insurance the buyer may want to carry. Next item is materials regarding condition of the property, and that's the seller's phase 1 or phase 2 reports that the seller may have. Now, section 9.1D of the purchase and sale agreement requires the seller to provide a copy of the soil report, but that's different than the phase 1 or phase 2 report. So if there is a phase 1 or phase 2, arguably, if they show bad facts about the property, if they show that there's potential contamination, the seller would be duty bound to disclose that anyways. But it's always a good idea for a buyer to ask for the seller to provide a copy of a phase 1 or phase 2 report that the seller has in their control and possession. Next is a list of license and permits that benefits the property, especially if there's conditional use permits or very unique permits that are applicable to this property. Those are always good to get copies of those license and permits. Any plans, drawings, and specifications that the seller has for the property. This is invaluable for the property management and for doing remodeling or construction work post-closing. Having those plans and drawings is very, very helpful to the building engineers and also to the architect if there's going to be a remodeling. Next is the list of warranties. What are the warranties with respect to the heating, ventilation, and air conditioning system, the roof, and if there was a contractor who did some work, what is remaining on the contractor's warranty? Finally, a zoning verification letter from the city, the municipality, regarding the property's current zoning and compliance with laws. This is a great item to get, as you need the zoning verification letter to get the title insurance company to issue a zoning endorsement. There's a little bit of a ramp-up time. You have to remember to do this with the municipality right when you open escrow, so it doesn't jam you up and you run out of time. From the seller side, the estoppel certificates are a critical item because, as I mentioned earlier, providing estoppel certificates is a due diligence contingency. So if you have a property that has obviously a lot of tenants, that's going to be a lot of work for a seller to go get estoppel certificates signed by every tenant, not knowing whether the buyer is actually going to go through with the deal. So quite often people would revise the estoppel certificate arrangement to change it from a due diligence contingency to a closing condition. In other words, the buyer signs off on all the other contingencies, and a condition to the closing will be the seller to deliver estoppel certificates that are clean, or there's some other definition of the estoppel certificate form that's going to be acceptable to the buyer. So this is something important if you have a lot of tenants in the project, and from a seller's perspective, it's a very helpful change to make so you don't end up spending a lot of time getting these estoppels and the deal then doesn't close for some other reason.
Bryan, do you see many cases where the seller just can't get estoppel certificates, and what generally happens then?
Well, in the AIR purchase and sale agreement, the contract allows the seller to deliver an estoppel certificate instead of the tenant. If I'm the buyer, I would not be too happy with relying on a seller estoppel certificate, since that means that if the seller's misrepresented the state of the lease in the seller's estoppel certificate, then now I have to sue the seller for breach of warranty, etc. And that's just the buying a lawsuit. The fact that a tenant refuses to give an estoppel certificate is a telltale sign that there is a problem there. So that should alert the buyer right away to find out what's really going on with this tenant and what's the reason that the tenant is refusing to give the estoppel certificate. So if you have to rely on a estoppel certificate, it'd be good to combine it with some kind of a holdback in escrow so that there's some of the money held in case there's a breach of the seller's statements in the estoppel certificate. So there's something securitizing that seller estoppel certificate. As I mentioned earlier, the contract gives the buyer a free look. And as a seller, you may want to change this to have that buyer actually perform due diligence. For example, doing an inspection or adding a provision that the buyer has to use commercially reasonable efforts. I've seen this quite often with getting a loan, and have the buyer submit loan application and provide seller copies of the loan applications, etc. Or you want to get a pre-qualification letter before you accept the buyer's offer. My experience has been that with these kind of additions, what you're inevitably going to end up with is a dispute as to whether or not the buyer did meet the requirements in the contract that you've added. And oftentimes that ends up prolonging a termination of the contract. When the buyer has decided not to buy and the seller is trying to get the buyer to forfeit a deposit, it ends up prolonging a dispute and puts a cloud on title of the property when the seller wants to sell it to the next buyer. So I don't see this happening quite a bit, where people actually require a buyer to do this kind of a commitment to perform due diligence. In long-term escrows, for example, if there's an entitlement deal where the land is being subdivided and the developer is a home builder who's going to go through the parcel split and get the entitlements to create a subdivision, it's pretty typical to ask the buyer to pay as you play. So the longer that the property is tied up in escrow, the seller will require the buyer to either put additional deposits into escrow or have the buyer pay those additional deposits to seller outside of escrow in order to have more due diligence time or extend the closing date. That change is where the rubber meets the road. If the buyer is really interested in still pursuing the deal, then they will put up the additional money. If they're not, then they'll cancel and they won't waste any more time. One of the things that I've seen happen quite often is where people have this additional deposit, they're not very clear as to what is this additional money for. This also happens with deals where the parties sign and go hard, which is not happening in today's market. It was very prevalent 3-4 years ago. You have to be clear about what this additional money is for, and oftentimes it's money that's given by the buyer to the seller to either extend the due diligence period or extend the closing date. And when the buyer makes those payments, that has been earned by the seller. And you want to make sure that you don't characterize it as liquidated damages, because that only gets paid to the seller if the buyer has signed off on all the contingencies and fails to close on the scheduled closing date. And it's important to make sure you properly characterize the application of the money and what it's for, and is it refundable or not, and is it applicable to the price.